Okay, yesterday we looked at this fraudulent marketing, that courts are not courts of morals, they're courts of law. Okay? And the reason it's utter nonsense is because equity prevails in every court. And equity is about the conscience, and the conscience is what dictates morality or right from wrong. So that's one of the things that is a massive fraudulent misrepresentation. The other fraudulent misrepresentation is what goes on in the court, because what they've sold you is this belief, okay, that in the olden days we used to have fisticuffs, and the guy that got beaten up was the loser. And then we had sword fights, and the guy that won was the winner, and the other one was the loser. And then we had, you know, the pistol duels, and you turned and you shot one another, and the one that was alive was the winner. And they tell you, now what we've got is battles of paper, okay, and there's a winner and a loser. However, that is not true. Again, when we look at the facts, the evidence, that is utter nonsense. All right? Courts are not adversarial. Those days are long gone. And that's a myth created by them saying, okay, on the one side, we've got the defendants bringing all of their bullshit, and on the other side, we've got the prosecution bringing all their bullshit. And then the judge sits there neutrally, listen to this rubbish. Based upon what I've seen before me, I must make my judgment. Okay? So what I'm doing now is going to show you that even Parliament assembled has legislated that this is nonsense. And we're going to look at what should legal professionals be doing as opposed to what do they do. So let's again go back to the source of the problem. We go and ask a lawyer to represent us. Do you actually know what they're meant to be doing? So you're happy to give them money, but you don't even know what he's meant to be doing for you for that money. Okay? So we're going to start with the common law first, to see in the common law what is their job. So, misleading the court is regarded by the court and must be regarded by any disciplinary tribunal as one of the most serious offences that an advocate or litigator can commit. This is serious crap. Basically, misleading the court is serious. Why? Yesterday we looked at contempt of court. Anything which biases one party is a contempt of court. Okay? And it goes on to say that such conduct will normally attract an exemplary or deterrent sentence. Okay? And it goes on to say, this is because the system of the administration of justice relies so heavily upon the integrity of the profession and the full discharge of the profession's duties, and in part because of the privilege we the people have granted, the privilege to the Bar Association and the privilege to the Solicitor Regulation Authority and to the SILEX, the Institute of Legal Executives. Okay, this is a privilege we've given them, but do we know what the terms and conditions are of this? So, what it is if you are representing somebody else, not only must you follow the rules to the letter, but equity is over substance, and therefore you need to follow the spirit of the rules. Okay? Honor, good faith, clean hands. Okay? And this is what the common law says. This is what people have created, us. We've told them this is the rules of the game. Okay? So this year has been legislated for Queen's Counsels. I suppose they're going to change it to KCs now as well, King's Counsels. Barristers, solicitors, magistrates, legal advisors, any officer of the court. Okay? So the first thing is they're called officers of the court. That should give you a clue who they work for. Right? So basically the Legal Services Act codifies the common law. So it's a legal obligation as well as a lawful obligation. Okay? And so basically in this section of the Legal Services Act Part 1, they are authorized persons who are obliged at 3 to adhere to their professional principles. And I've got to update this because Ryan pointed out the link isn't right. Okay, an updated version, basically in Schedule 2 and Schedule 5 it defines an authorized person and that the professional principles are set by the Solicitors Regulation Authority, the BSB, the Bar Standards Board's handbook, and the Silex Code of Conduct. So when you go through those...
Mark, that SRA handbook, I've got it here, was it was replaced by the Standards and Regulations on the 25th of November 2019.
I don't know. Just, you know, we've got it checked, okay? It may well have been replaced, I don't know. Okay? But this I started using, it could be that it has been changed afterwards, but it's still up. Anyway, we need to check that. Right, now within there, what it says is, common to all of these legal professionals is, your overriding duty and obligation is to uphold the rule of law. So for this privilege, these are the terms and conditions. Over the constitutional principle of the rule of law. Your duty as a legal professional includes the duties to the court. And they have an obligation to the court to provide the court with all relevant information in favour and in dissent of their client's position. It'll be in there. Trust me, it'll be in there. But we will double check, okay? And in any event, if it's not in there, guess what? The rules of equity prevail over the common law, and therefore, not only have we got the common law that says the letter, it's the spirit. Okay? So they can't overcome the obligation. Now, so then comes your client. So the privilege is to uphold the rule of law, follow the rules of the court, put the court with all relevant information to make your decision based upon the evidence. So what that means is, if we're looking at a magistrate's court, you've got a prosecutor. The prosecutor must put both sides. The defense must put both sides, and the legal officer must put both sides. So there's 3 people making sure that the court is making the full knowledge. Kerry? No. The court is with full knowledge to be able to make a decision. But guess what, guys? There's this thing called ignorance of the law is no excuse. So what's been happening in the magistrates' courts with the council tax is the magistrates now are quoting back word for word what their legal advisor tells them. Sorry, mate, no longer will that start, because ignorance of the law is no excuse. So one way or the other, we will be able to hold these people to account. Now, there's a special obligation with dealing with litigants in person to use, guess what, plain language. So there's your Justinian deception, legalese, definition of person, all of this rabbit hole stuff. It's utter crap. It's not borne out in the evidence of fact. Okay? And equitably, simply what it does it boil down to? You cannot claim what you have no right to claim, and you cannot create a dispute where none exists. Why? You're breaching somebody's peace then. Okay? And since we've started using this, we're starting to get solicitors to behave themselves. They come with bullying tactics because the only thing they know is the threats of violence and actual violence. Okay? And once they know that you understand the rules of the game, they start to change their behavior. Okay? So last week with Ahmed, we had he's brought a case against the DWP for an attachment of earnings. And how did the solicitors react to this? If you don't bloody withdraw it and sign this consent order by tomorrow at 4 p.m., we're going to put in an application and that's going to cost thousands and you're going to end up paying the bill. So at 6 p.m., we replied to them with this and said, listen boys, in accordance with the CPI regulations, blah, 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 you have not responded, therefore what you filed is bullshit. In breach of the civil procedure regulations. Further, your threats and intimidation is not acceptable, and if you continue behaving like this, we'll bring it to the attention of the court. And can't remember what else we put in there, but essentially that was it. And at 6:58 p.m. we had a response from them saying, thank you for your correspondence. We will be looking into these matters and we will revert to you. Okay? It works, this stuff. So basically, the important thing is when you're dealing with these guys, you've got to say, I don't care what you believe, this is your job. Those who stand on their rights harm no one, those who don't have none. They'll steamroller you all the way through. Okay? So that there's the legal profession. Then you've got the judicial officers. All right? Now we've been having a problem with, in the magistrates' courts, that they don't want to give their names. Who had it on their desk yesterday? The judicial, the equal treatment bench. Somebody had it on their desk. You got it. Yeah. Okay, we've got so many tools available to us, and if we don't use them, you know, whose problem is that?
Section 63 or something.
Okay, so this piece of paper, okay, get a cleaner copy so the purple really sticks out, and all you need is this front page. Okay, because this here tells you what should be going on in the court. All right, so it's part of the judge's training. Equal treatment bench book. Okay?
Basically for litigants in person,
Yeah.
how they must treat us equally. And as it's an acknowledged we're at a disadvantage.
Should get t-shirts, mate.
Their professional level should be at a disadvantage.
Yeah, you should.
Okay, I can guarantee you that they have no idea about this. Okay? And they definitely don't know what's in there. But, guess what? Are you familiar with the Equal Treatment Bench Book, Your Honour? From the Judicial College, where you've done your training.
Will you be following this?
Well, even before that, you first ask them, are you familiar with this? How are they going to react? Oh, really? But they definitely won't react. Why? Because they've got a bloody ego. Equal treatment. Of course we're familiar with this. Do you think we're idiots or what?
Yes.
Okay, that's the way they react when you just simply pull this up and you ask, are you familiar with this? Well then, in accordance with section 63, can I have your name please? Okay. Right. Not only that, and we'll be going through at the end to show you how it should operate, okay? But that sets out three principles, okay? Or basic, this is the fundamentals of what's in there. Judicial independence, impartiality and integrity. Then it goes into more detail about ensuring equal treatment. They should be competent and they must be diligent. Okay, so the summary in essence, okay, is that it is what you can expect them to be doing, what they should be doing, okay, as opposed to what they do. Why? They become accustomed to doing whatever the hell they want, right? And ignoring litigants in person, and not making rulings based upon the evidence, and not evaluating the law. Whose fault is that? Ours. Why? Because we don't know what the hell they're meant to be doing. And we turn around saying, oh God, they're all bloody Freemasons, and they're corrupt, and they're this, and they're that, and they're the other. What are we doing then? We're totally disempowering ourselves. Oh, I'm a poor little victim of the system. Okay? We have a choice. Spend a bit of time, learn the basic rules of the game, okay? And then use those rules because those rules are good. So all you're doing is mirroring the system back upon them. And it's very difficult for them to deny it then. Because it's their own rules. Okay? But basically, the manual goes into the more detailed stuff. But judicial independence basically is, the judiciary was said yesterday, is got one function. Okay? Any two parties disputing who can't resolve matters in private to return to the peace need to go for public dispute resolution. Okay? That's the function of the independent judiciary. Based upon the evidence between the two arguing kiddies, okay, based upon that evidence alone to make a decision. If the judge has better knowledge than what they're presented by the kiddies, then they present that information so that the kiddies can argue with the judge about it as well. However, they cannot introduce anything outside in their judgment. And like we saw yesterday, okay, under section 66 of the magistrates' courts, even the magistrates must give you a reasoned decision. Unfortunately, I only picked this up later, but now, even in the magistrates' courts, we can turn around and say, we judicially noticed you about the Bill of Rights, the Coronation Oath Act, the Act of Settlement. Why have you not considered that? Because it says nothing can be done to my prejudice, and therefore the Local Government Finance Act 1992 is illegal according to their own rules, because Parliament is constrained, they can't do anything to my prejudice. Yet, what is the Local Government Finance Act? It's to my prejudice. They wouldn't take my money. That prejudice has been pretty damn big. So therefore, how on earth have you come to the reason that you're going to issue a liability order against me?
That's powerful, that is. That's next step.
Massive.
Yeah.
For housing without cost as well.
Yeah, and we'll talk about equitable costs and all of that. The other thing is, why have you ignored the creation of that liability where I've asked them to prove joinder as to how I am bound to the Local Government Finance Act? Come on, Your Honour, explain that. They can't.
Now, remember that most magistrates don't say a word.
Correct.
You've got that.
Correct. I've just
That
issued a liability order against you, end of.
Yeah.
Okay? But now, with these tools, we can start to hold them to account.
I mean, in our case, you could see they were really nervous.
Yeah.
So, you know, they were reliant upon that clerk of the court.
Yeah.
They didn't
And the
want-
clerk of the court, in your case, actually lied.
Yeah.
In my case, in our case, the six of us,
Yeah.
okay, we had a district judge.
Yeah.
From what you're saying just now,
Yeah.
I should be writing a letter, a personal letter, to Judge Stephen Leake.
How based
And
upon
saying
the
all of
evidence
this.
you do, correct. Okay, and we'll be looking at section 142s and section 111s. How to, again, try and force this. So, why is it independent? It must be because anything which is not independent biases one party, and therefore any order that comes out of that is void. Okay? So, the independence, like we saw yesterday, is included in the Lord Chancellor's oath. That's his contract, that's the law, simple. Mr. Lord Chancellor, why are your courts not operating independently? You've got 28 days to fix it. here's all my evidence. In all these different magistrates' courts where we've been with the council tax, that they're ignoring what we say. They're not giving reasoned explanations as to how they ruled against us. And they've totally ignored the question of joinder. Okay? And not even asked the council, what on earth created this liability? How has this liability been created? They're avoiding all this nonsense. So 28 days, come up, give us a plan for the solution as to how you're going to stop this nonsense in your courts. And if you don't, guess what? We're going to take a prosecution against you. We're going to put Calvin on you. Okay? So it details with all of this, but essentially, what is it? If there is any way that the judge or magistrate has some connection, okay, to either party or a point of view, that there raises a suspicion of bias, and therefore they should recluse themselves. Okay, so when we were with these COVID cases that I've been helping people with in court, I've never asked the question, are you vaccinated? Yeah, I mean, it's an obvious question. I want to beat them even if they are vaccinated, which is one reason I haven't asked them, because I want to beat them in the law. Okay? But that there is an obvious bias when he's making a decision about something to do with CV. It's an obvious bias. Okay? So, when we need that tool, we'll use that tool. So, basically that's then, like I say, anything that biases means they must recluse themselves. Okay? This is their contract with you, with me. This is the law. This is how simple the law is. This is why ignorance of the law is no excuse, because there you got it. I will do right to all manner of people after the laws and usages of this realm, without fear, favour, affection, or ill will. What does that mean in substance? We all equal under the law, and nobody is above the law. And I will follow the due process of law. That's your contract. If they're in breach of their contract, we can hold them to account. They're acting without authority, and hence they're in person.
Could you just got that? You just skipped over that about the fee-paying judges. So,
Okay.
fee judges.
Magistrates are lay judges, okay, and they're not paid. So it's yous and me's who basically go and sit in court. Over, I think, a 2-year period, you've got to go to one, once a month or 10 times a year or something. You get a bit of training, go through the equal treatment bench book and a few other bits and pieces like that. And then you become a magistrate, you're a lay judge. You're not educated through the legal system. So magistrates are unpaid other than they have the right to claim expenses. As opposed to district judges or deputy district judges and all the rest of them going up, they are paid full-time by the public to be a neutral party to resolve dispute. Just like the police are paid full-time by the public to keep the peace, protect people and property according to law. Okay, so basically that's the difference in structure. However, what they've been relying on in the magistrates' courts is, I'm not legally trained. I'm doing what the legal officer is telling me to do. Because it's their job, it's the officers of the court which must put me with all the relevant law in favour and dissent based upon the case which is before me. And quite simply, ignorance of the law is no excuse. Therefore, if they've misled you, Mr. Magistrate, your problem. Ignorance of the law is no excuse. So again, we can start to hold them to account with what simple mirror, what they use against us, we just simply use against them. Does that sort of answer What do you mean?
Oh, well, sorry, backing up just one. I mean, what about the judges that we've asked that aren't underwriters?
Okay, now there's different ways of skinning a cat, all right? So we'll be going on, at the end, literally, there's like 6 pages of questions, set-up questions, that we can start to use to get them committed to a position. So, okay, with my hearing, if it would have gone ahead, I would have done it differently because I was applying what we've learned. In yours, did we use judicial notice?
We could give them a section 111.
Okay. So anyway, then in the next lot of Malden District Council, whatever that was.
115.
Hang on. Basically, when we went to the next set of hearings, magistrates' hearings, with Lance and Angela and somebody else, I can't remember who it was. What we did was, we took the Bill of Rights and we said, we're judicially noticing the courts, and we gave it to the clerk of this. We're judicially noticing the court of the Coronation Oath Act. We're judicially noticing the court of the Act of Settlement. They still ignored us. Okay, so what I was going to do at the next hearing, and this is when I finish the update on the council tax, what we need to do is, because basically they're treating us as lay idiots. Okay? Now, who the hell are you? What do you know about law? Okay? They are not looking at the evidence. They don't understand judicial notice, these magistrates. So what we're going to, I'm going to be telling or advising people to do is, if Dwayne's the legal officer, can you please confirm to the bench that the Bill of Rights is current statute law? Come on, check. Confirm to the bench. Can you confirm to the bench that the Coronation Act 1688 is current statute law? Come on, confirm to the bench. Can you confirm that the Act of Settlement 1700 is current statute law? Now the bench, because their officers told them, has no choice. So we're learning these things through experience, okay, to hold them to account.
So before you do that, in terms of the Bill of Rights, I know it's slightly different, but where you showed us earlier that obviously there's a whole 7 pages of amendments to
Secondary legislation, yeah.
secondary legislation.
Yeah.
Does that apply to primary as well, or only secondary?
Well, primary legislation, they keep updated. Okay? Oh, I forgot to share. I think there's something like over 250,000 pieces of secondary legislation or something like that. I mean, there's just so much stuff. I mean, it must be, I'm sure you could fill this whole room with all the legislation they got.
So does it affirm anywhere that the Bill of Rights isn't changed? Like, I mean, in terms
Yeah, no, on the Bill of Rights it tells you.
But you,
There are no current outstanding. Okay, let's just quickly jump back to the internet, yeah. Okay. Ah, that's the There are currently no known outstanding effects for the Bill of Rights.
and what's the question mark? Does it take me away to say something? Or?
You can't choose the original as enacted on that, can you? There's a,
You might. Some of the older stuff they can, some of them they can't. Okay, revised legislation carried on the site may not be fully up to date. This will tell you what things haven't been applied. So you'll always see on the top of an Act of Parliament what changes have been applied, what changes haven't been applied. Okay? So basically, okay, can you confirm to the bench that this is current statute law? Okay.
But that declaration, that green strip there,
Yes.
it's admission that it is current.
Correct. So what did we have? I think I might have said about Debbie's COVID case. Carry. Basically, we cross-examined the policeman first question was, can you confirm your oath, affirmation or attestation? And that's the first policeman that actually could. Okay? And the one in Devon or Cornwall couldn't even flip in, he didn't even know what his oath, affirmation or attestation was. So the question, and I think I said this yesterday, okay, was the, so therefore your contract is to keep the peace, protect people and property according to law. What lawful excuse did you have to breach Debbie's peace? Oh, COVID regulation, da 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 da. Regulation, law, did the two words sound the same to you? What makes you believe regulation is law? He admitted that he didn't know the difference between primary legislation, secondary legislation and law. And then we pulled out the Act of Settlement 1700 and said, Section 4, in the first sentence, are you aware that law is defined as my birthright? Immediately the barrister from the CPS jumped up and said, oh, that's old, you can't use it. Okay? A barrister, a trained legal profession. So we went through this 6 months, 3 months, 5 months, 5 years, 10 years, 20 years. How old is it before you can't use it then? Okay? Eventually she admitted it's current statute law because of it's not been revoked. Okay? So then we asked the question, what if the police don't know the difference between what is law and what isn't law? How the hell can they be doing their jobs? And the bench turned around and said, we are telling you, it's not the police's job to know the difference. Okay, and you wonder why we're in such a mess. Nobody knows what the hell they're meant to do. And everybody's just running around like a headless chicken. So, what is the biggest comeback we're getting from the council tax challenge? Oh, this is an internet template and it's using ancient legislation. Just about every council has come back with that. I don't care if it's ancient or not. So now we're specifically asking in the notices, can you confirm the Bill of Rights is current statute law, Coronation Oath Act is current statute law, and the Act of Settlement is current statute law? Tell me, yes or no. That's it, you've got a simple choice now. Once we've committed, or they've committed to that, then we can develop our arguments later. So this is what we call leading questions. What we're doing is trying to extract a position out of them where they are committed. Because once they've admitted that the Bill of Rights is current statute law, then I can say, can you confirm in the first sentence that we the people are the principal and they are agent? Yes or no? And then we can go on to say, can you confirm that it says no doings can be to the prejudice of the people? Yes or no? And then we can go on to say, well, your claim is the Local Government Finance Act 1992. You want money from me? Is that to my prejudice, yes or no? Well, hang on. You said that you agreed that they can't do anything to my prejudice. So therefore, Local Government Finance Act, by their own admission, becomes illegal. They have no legal authority for it. It's void.
Should we use that argument in the in magistrates' courts?
Yeah.
Because we should just
Correct.
get, because the one thing is you realise is that the magistrates are mute. They're just sat there at the back.
No, just
The main argument is with that the legal counsel that's at the front,
yeah.
and she's doing all she can.
It's the clerk.
Clark,
They're the ones that.
they're the ones
control
they're the ones you've got to get through.
Yep. Okay. And
But it's the same as when I was out with Lena when they were, the police were protecting those, what are they called?